from what we say in England, the concept of where it has emerged regarding the defenses of unsoundness, and whether the mental insanity and the sanity as such, is there a subtle difference with legal sanity? Is there any subtle difference between the two? These are the certain broader contours upon which, wherein we had requested Mr. Vishwanath Angadi, a former principal judge from Bangalore, to share his insights. And those who have been connected with Beyond Law CLC know it very well that we have taken sessions with Mr. Angadi on different topics, normally which we don't find as such even on the YouTube, etc. And he has always been kind enough to share his knowledge on such aspects, which I can only say that as the holy season is coming, as Holi has different colors, just like akin to a rainbow, he also showers his different knowledges. And when we actually go through entire this thing, it gives us a bright colors and a more sense of happiness while we hear to his talks and his knowledge. Without taking much time, I would request Mr. Angadi to take over. Over to you, sir.
Thank you, Mr. Vikas. Thank you, the esteemed men in the department who are logged in. Wish you all a very happy Holi. I hope today you must have observed, and it may go on even for a week or so. The topic for discussion is rather very interesting. In a case before a criminal court, in many a times the accused sets up the plea of insanity. He contends that the accused was of unsound mind when the act or overt act was committed. And more so, in grave offenses, this defense is taken rather, in my experience, invariably. What about duty of the prosecution to dispel the ground of attack made by the accused, to say that the act he did was on account of mental delusion? What about duty of counsel for the accused to prove this aspect of insanity of the accused at the time of the accident? As you all know, the IPC contains a chapter called as General Exceptions, that is sections 76 to 106, both inclusive. There we have got this section regarding section 84 of the IPC, which speaks of the aspect of act of a person of unsound mind when the accused can seek shelter under this exception, and the court in many times is required to acquit the accused, even though the act was complete. The man who was to be stabbed, he is no more. So my endeavor is to take briefly the backdrop as to how we are on our statute book 84 of the IPC. And before that, I will trace the history of the particular law in England, because I borrowed virtually the entire text of the IPC, which was enacted in 1860. Even though 160 years plus have passed, this IPC has very little amendments, except now we speak of electronic evidence, we speak of something else, but in basics, they have remained unaltered. I will put you some questions. So I cannot talk with you physically like a classroom, but the doubts which the counsel for the accused or the prosecution or the IOs or even the courts may have in their mind in the sphere of how to give effect to or how to grant the benefit of the accused being insane or being a person of unsound mind at the time of commission of the offense. Whether conduct of the accused prior to the incident, at the time when he committed the incident, and post conduct after the incident, are they also relevant or not? Conduct prior to, conduct at the time of office, of the offense be committed, and conduct after or subsequent to the date at the time of offense. Are they important or not? Number one. So what the IPC says, at the time of the incident, he must have that mental delusion. Whether before or after the incident, whether mental disability of the accused can the court or the IO is required to examine. The first one. Number two is, what about degree of proof? How the accused shall prove this burden cast upon him? Is it on par with degree of proof which the prosecution must discharge in every case? That is proof beyond all reasonable doubt. That is the general criminal law. Every offense is said to be committed by an accused when he was sane, and the general law on the point is the prosecution shall prove its case beyond all reasonable doubt. Whether this same yardstick applies to the aspect of proof of insanity by the accused before a criminal court or not? Or is it something lesser? Or is it the same? Or what about the standard of proof which the accused must go forward to prove and seek the benefit of 84 of the IPC? The third point is, in a given case of the apex court, plea of insanity was taken before the apex court, Supreme Court of India, for the first time. Whether in the appeal before the High Court, or appeal before the appellate courts, or appeal before the Supreme Court of India, can this plea of insanity or the accused being of unsound mind, can it be raised for the first time during the appeal stage or not? What about law on this point? The next point is, we have got two types of what we call insanity. Firstly, what is called as legal. Number two, what is called as mental. Both have got separate and distinct meanings. And we have got case law of the apex court on the point. Which insanity, is it legal or mental, with which we are concerned while holding a criminal trial? Can a judge hold that, yes, the accused was having mental incapacity, insanity, and can he acquit the accused? Or what about the aspect of insanity which the court must look into? Is it legal insanity or mental insanity? The next important question is, the IO, after arrest of the accused, comes to know that this accused, in fact, he is not behaving properly. Or before he is produced before, or the time when he produced before, the magistrate, after the FIR, for obtaining the remand order, either police custody or JC as the case may be, the magistrate notes in the order sheet about mental condition. So what about duty on the part of the magistrates, duty of the police once FIR is lost against the accused? What duty they have to perform is also matter which has to be seen. The last important study of the facet is the IO in a given case does not produce medical records with regard to the past history of the particular accused who did the overt act. And in the course of the trial, the defense taken is defense of insanity. So whether the accused, on account of the offense not being proved beyond all reasonable doubt, and if some doubt is created in the mind of the court, can court extend the benefit of doubt to the accused or not. So with this, the next point is 84 of the IPC. 84 of IPC says, nothing is an offense which is done by a person who, while he did the act or overt was of unsound mind. So on account of unsoundness of mind, if an act is committed, then the section says, and one more point is, he must not be capable of knowing the nature of act as to what is doing is wrong or contrary to law. So here the words used as acts must be wrong or act should be contrary to law. If in any one of these things the case falls, when the accused committed the overt act, he can seek the benefit of 84 of the IPC. So how to prove this important element? Accused being unwell in mind, number one, not knowing nature of acts. Number three is what is wrong or what is contrary to law, he is not able to distinguish. If these things are fulfilled, then the court shall acquit the accused. If there is proper evidence let in by the prosecution. So the word, there's no definition of the phrase unsoundness of mind used in 84 of the IPC. IPC has not defined the phrase what's called as unsoundness of mind in the beginning of the code, and as per codes, unsoundness of mind is on par or is equal to what is called as insanity. So insanity or what is called as unsoundness of mind, they are used simultaneously. They are used as corollary, and that they stand in only one important compartment. So insanity is used to describe varying degrees of mental order. So with this brief, statement with regard to the aspect of 84 of the IPC, I will now take quickly about the origin of the law of insanity in UK. The first case is namely Rex versus Arnold of 1724. In this case, they laid down the test called as wild beast test. In this case, Edward Arnold attempted to kill and even wound one Lord Onslow and was tried. Accused was suffering from mental disorder. And in the trial, the court could notice that he could not distinguish as to what is good or evil and did not know what he did, though he committed the greatest of the offense. So in this case, the court held that if the accused was of unsound mind and could not distinguish what is good from evil, did not know nature of the act committed, the court held that accused shall be acquitted. This is called as the wild beast test, not able to distinguish what is good or what is evil, and the accused not knowing nature of act committed. So with that, the second case is Hadfield's trial, as it is called commonly. It's a case of 1800. In this case, this is called as insane delusion test. Hatfield was discharged from army because of insanity and mental disorder. He was tried for treason in attempting to assassinate King George III. Counsel appearing for the accused proved that Hatfield only pretended to kill the king and is not guilty because he was insane when he committed the overt act. The court stated in this case that insanity is to be determined by the fact of fixed insane delusion and such delusion under which the accused acted is the main reason of the crime. So this is the second case, insane delusion test. The third case is what is called as Bowler's case of 1812. In this case, the court held that the jury in England has to decide when the accused committed the offense, whether he was capable of distinguishing what is right from wrong or under mental illness. So here the point is whether the accused is able to distinguish what is right from wrong. This is the case on the given point. The last case is McNaughton's case of 1843. In this case, the accused McNaughton was suffering from persecution mania, and because of disease, he thought that whatever difficulties he is facing is because of British Prime Minister Robert Pell, P.L. Pell. And here this McNaughton shot dead the private secretary of the Prime Minister by name Drummond. And he thought that he is killing the Prime Minister, but by mistake, he shot at the private secretary of the PM. And in this case, this thing happened when McNaughton was sick. He pleaded insanity before the House of Lords. And House of Lords, consisting of 15 judges, they decided the particular point of law. Out of 15, 14 judges concurred that the accused, McNaughton, was suffering from mental disorder and they acquitted the accused. So here, he was not able to distinguish what is right from wrong. In this case, they laid down 4 principles and they are ingrained in section 84 of the IPC. First point is, if the person knew what he was doing or was under a partial delusion, then he is punishable. Number 1. Number 2 is, there is presumption in law that every person is prudent or sane and knows that what he is doing and he is responsible for his act. The third important principle of the case is to establish defense of insanity at the time of commission of the offense. The accused was in such a state of mind that he was unable to know nature of act committed by him. The third point is, accused should know that he was not able to assess the nature of the act which he is committing. The fourth important principle is, it is for the jury to determine whether the defendant or the accused was suffering from insanity, and evidence from medical experts on insanity cannot be asked for by the prosecution. So with this brief prelude, I will take now quickly case laws on the point. The latest case law of the Supreme Court, not very latest, it is now nearly 3 years old, by 2nd of July of this year. This is a very important case where the lordships of the Supreme Court of India have touched various legal facets with regard to the plea of insanity. So the case is Devi Loka Rathod versus State of Maharashtra. That is the 2018 Part 7 Supreme Court cases, page 718, 718. The judgment is penned on by Justice Naveen Sinha and another. And here the plea of what's called as unsoundness of mind was raised by the accused in the criminal case before the Court of Sessions. I will tell you the brief facts because saying principles will be of no use for me unless I tell you the brief facts of the case. I will take only 2 minutes. If we know the facts properly, we can appreciate various facets which the court is required to consider to give benefit of the invoking of 84 of IPC or not. In this case, the offense took place on 26/9/2006, wherein the accused Devi picked up a sickle from the floor of shop of an ironsmith, attempted to assault PW11 Gulab Pawar, but which injured Sri Santosh Jadhav, one more injured. On the same day, he later assaulted PW3 Ullas Rathore, and he gave further blow on the stomach and back of the deceased Harish. So it's case of death of a person, injury to 3 persons. And when he later tried to intervene, so the accused tried to run and threw sickle on the way. So the accused after assault, after killing Harish and injuring 3 persons, he tried to run, threw sickle on the way, and the villagers apprehended the accused and handed over the accused to the police for further inquiry. And here, the police, upon full-fledged investigation, filed charge sheet before the court at Akola, and the defense raised was defense of insanity. So the trial court did not accept the evidence of DW1, Dr. Sagar, whom the accused examined, and thereafter the matter was taken to the High Court by the accused. High Court also confirmed the order passed by the trial court. The second appeal by the accused before Supreme Court of India, the apex court went through judgments of 2 concurrent courts and based on materials on record, acquitted the accused on the plea of insanity which the accused had raised before the trial court. So the judgment of the trial court, judgment of the High Court, which confirmed the judgment of the trial court, was set aside by Supreme Court, and the apex court invoked 84 of the IPC, and the accused was set free from the charges. So in this case, various facts came into consideration before the apex court. The apex court touched various factors. I will tell one by one. All these factors are based on case law on the relevant point. The first point is appellant was very pure, was very poor. He had very less means. Appellant was very poor. He had engaged counsel of District Legal Services Authority at the trial court, and he availed services of High Court Legal Services Committee or High Court Legal Cell. So in both the courts, the accused could not engage good counsel. He engaged counsel of the legal services institutions. That is number 1 point. The second point is the IO arrested the accused on 26/9/2006. So upon the offense, the villagers apprehended, police came, they arrested, the police took custody of the accused. And the police took accused to custody on 28/9, after 2 days from the date of apprehension. So for 2 days, the police did not arrest the accused because the accused was not well and was taken to hospital for treatment. After incident, police apprehended, and for 2 days they did not produce accused before the magistrate. They took him to hospital for treatment. So this is one of the important things. So number 3 is, because here the point is treatment was there for mental illness. This point I did not tell to the trial court in the course of filing records before in the charge sheet. The third point is information of arrest was not given by the police to the sister and mother of the accused, who were very much there. Mother and the sister and the accused were living together. Upon apprehension of the accused, the information was given to the friend of the accused, but not to the sister and mother of the accused. And this particular friend was not examined by the prosecution. I'm saying you all these things because on all these things, all these important facts, the Supreme Court of India disturbed the order of conviction rendered by the trial court and the high court. And one more point was that there was previous history of insanity. This point the police overlook. One more point is the apex court in this case observed it was the duty of the IO or honest investigator to subject accused to medical examination immediately and place evidence before the court. In this case, the IO felt that the accused on apprehension was not able to respond properly. They referred him to hospital for 2 days, but the police did not produce medical records of treatment for 2 days in the hospital. The apex court observed that it creates serious doubt in the mind of the court and there is serious infirmity in the case of prosecution. So in this case, on all these important factors, the accused prayed the apex court to give to him benefit of doubt, invoking section 84 of the IPC. And in this case, the apex court touched various facts of various cases involving ratios on the point of section 84 only, and they are more than 10 in number. All those judgments of the apex court, the apex court made use of in writing this judgment. So the first point is, namely, in the case of Bapu versus State of Rajasthan 2007 part 6 SCC page number 66. In that case, the prosecution deliberately withheld relevant evidence regarding mental illness of the accused. His mental illness at the time of the assault being committed and the accused requiring immediate in-care treatment in hospital after assault, and there was hindering of his arrest, and the report of diagnosis, the report of treatment, evidence of treating doctor, all were not produced before the court. So in that case, that is Bapu versus State of Rajasthan, as I told you, the apex court held that it cast doubt on the credibility of the case of prosecution. And when the court gets reasonable doubt, the apex court held in that case that condition of mind of the accused is an important point involved, and important lacuna is there in the case of prosecution, because prosecution did not produce medical records of the accused after his apprehension. He going to hospital for treatment, all those things. So in this case, the apex court gave to the accused benefit of doubt and acquitted the accused. So the Supreme Court of India, in this case, also made use of the ratio of the apex court in the case of Bapu versus State of Rajasthan 2007 part 6 part 8 SCC page number 66. The second point which the apex court in this case observed is that law presumes every person committing an offense as sane and liable for his acts. That is the mantra of 84 of the IPC. And that it is for the accused to prove that he was insane when he committed the offense. So the question is regarding burden of proof on whom it lies. So the apex court held in this case that burden of proof lies on the accused. And for that, the Supreme Court case law is Dayabai Thakkar versus State of Gujarat, AIR 1964, Supreme Court, page number 1563. So, with regard to the aspect of burden of proof, what about case law? Burden of proof on the prosecution, burden of proof on the accused, both are different as per the apex court decision in the above case. The apex court held that prosecution shall prove its case beyond all reasonable doubt. So there is no other excuse. Prosecution shall prove its case beyond all reasonable doubt. That is the first important thing. Second point is that the prosecution should prove that this act was committed by the accused and he had mens rea, and burden rests on the prosecutions from beginning till the end of trial. Number two is the rebuttable presumption that accused was not insane when he committed the offense. 84 comes here. Accused can rebut it by saying to court that he was insane when he committed the overt act. So the accused shall prove that he was insane when he committed the act, number one. Number two, he must lead evidence, either oral or documentary or even other evidence also. But here, the apex court held burden of proof on the accused is not as of the prosecution, namely proof beyond all reasonable doubt. So as regards accused, the burden of proof is no higher than that rests upon a party to a civil proceedings before the regular civil court. So burden of proof on the accused is at a lower level compared to burden of proof on the prosecution, which is the burden proof beyond all reasonable doubt. The third important point which the apex court laid down in the case of Dayabai Thakkar is namely, even accused not able to establish conclusively that he was insane. Accused is not able to prove conclusively that when the overt act was committed, he was insane or he had some mental disorder. But still, the apex court held that if the evidence placed by the accused before the court raises a reasonable doubt in the mind of a court as regards one or more features of the offense, namely including the feature of mens rea, and in that case, court has to acquit the accused by giving to the accused what is called as benefit of doubt. So accused need not prove conclusively that he was insane, but if he gives to court some material to show that he was unsound in mind when he did the overt act, then the accused shall get the benefit of doubt and he shall be acquitted of the charge. So this case law also the apex court made use of in acquitting the accused in the case of which we are concerned. The next point is honors of proof under section 105 of Indian Evidence Act. As of prosecution is test beyond reasonable doubt. So honors of proof on the prosecution is proof beyond all reasonable doubt. That is also a thing which the apex court discussed in the above case. The apex court made use of decision of the said court in the case of Surendra Mishra versus State of Jharkhand, 2011, Part 11, Supreme Court cases, page number 495. So, accused only has to establish his defense regarding insanity. Accused has established the plea of insanity on preponderance of probability, after which the onus will shift on the prosecution to establish that exception is not applicable to the facts of the case. So, burden on the accused if discharged, then the onus shifts on the prosecution, and prosecution shall dislodge the burden of proof which the accused submitted regarding his mental condition as on the date of the offense. The Apex Court also took note of a decision in the case of State of Rajasthan versus Shera Ram 2012 Part 1 SCC page number 602. In this case, the Apex Court held that it is not every and any plea of unsoundness of mind of the accused that will suffice. The Apex Court held in that case, it is not every and any plea of unsoundness of mind that will suffice. The standard of test to be applied is what is called as legal insanity and not medical insanity. I pose the question with which insanity were concerned. The Apex Court held were concerned with legal insanity but not medical insanity. The Apex Court held in the case of Sheraram that it is not every and any plea of mind of accused being unsound that will suffice, but the standard of test is namely of legal insanity and not medical insanity. The Apex Court held that once a person is found suffering from the mental illness or mental disorder or mental deficiency, which includes dementia, loss of memory, self-control, and at all relevant times, by way of appropriate documentary and oral evidence, the person concerned is entitled to seek the benefit of 84 of the IPC. So here the point is, we are concerned with legal insanity and not medical insanity. The next point is what is called as the Apex Court also discussed in that case, the case law of the Apex Court in Ratan Lal versus State of MP, 1970, Part 3, SCC, page number 190. In this case, the Apex Court laid down the ratio that defense of insanity has to be with regard to state of the accused at the time the act was committed and evidence of conduct of accused that preceded, attended, and followed the crime. So in this case, the Apex Court laid down that accused mental condition shall be number one, as on the time and date of the offense be committed. Number two, also the previous to the date of the offense and also subsequent to the date of offense and followed the crime. So accused to show that he was unsound when the accused committed the offense. So court can look into the health of the accused regarding mental health prior to incident, when offense occurred. Number three, after the incident. So that is the aspect of the decision in Ratan Lal versus State of MP. The next important case which the Apex Court in the above case made use of is the facts of the ratio of Vijay Singh versus State of UP, 1990, Part 3, Supreme Court cases, page number 190. In Vijay Singh case, the Apex Court held that if from the materials on record before the court, if there is a reasonable doubt as regards the mental condition of the accused when the offense committed, then the apex court held that the accused shall be given the benefit of 84 of the IPC. So the apex court held that if some doubt is created in the mind of the court regarding the mental condition of the accused at the time of occurrence, he shall be required to be acquitted, and court shall put him what's called as benefit of doubt. So that is the case law of the apex court in Vijay Singh versus State of UP. With all these case law in mind, the apex court in the case with which we are concerned, that is, I have told you the case is of 2018. I told you the brief facts also. So here the apex court, in the case of Devi Loka Rathod versus State of Maharashtra, after discussing all these legal issues in this case, upset judgment of conviction of the trial court, judgment of conviction offered by the High Court, and acquitted the accused because the accused was not mentally well when he committed the particular act or overt act of killing of a person and injuring 3 persons. So in this case, the apex court held in the Devadas case that in this case, one more point was injured witnesses of the accused in the court told that the accused was not mentally well. So as we all know, in many cases, the court will not believe evidence of the injured witnesses who are close relatives. In this case, the apex court held in case the accused was mentally ill or unwell, it is only the accused relatives, father or mother or sister or brother, who knows more about the health of the accused mentally on the date of incident, prior to it, and the apex court held merely because the injured witnesses says that he was of sound mind, or merely because relatives say in court that the accused was not mentally well, the court cannot discard their evidence. So the apex court held the duty of the prosecution to prove its case beyond all reasonable doubt exists from the beginning till end of trial. If some doubt is created, then the court shall acquit the accused. In this case, the points involved, namely medical visits of the accused to hospital in the prison for treatment. This one was not filed along with the charge sheet. Records of treatment in the hospital of the prison and nature of tablets prescribed for cure of mental trauma. All these things were not brought before the court by the IO, and the apex court also did not appreciate the duty of IO. IO did not give to court the records of treatment of the accused. This one, the court took it as a lacuna in the case of prosecution. So the deceased, the accused, the apex court observed, had pre-existing ailment for the period prior to the offense 26/9/2006, and in this case, the accused had filed a year before the trial court under Chapter 25 CRPC by saying that he is not fit to face trial. As you all know, the accused has right to file in the court application saying that he is not fit to face trial. And if the court holds that accused is mentally unwell during trial, the court shall postpone trial until the accused becomes all right mentally. So this case, this factor also, the trial court and high court did not go through, and the apex court held that all these lacuna in the case prosecution and trial court also did not give proper reasoning to convict the accused. So the apex court upset. One more point is sister and mother of the accused gave in court evidence regarding medical ailment, that is mental trauma, physical, what you call mental illusion. And they told that at times they were tying up the accused with rope at home many a times. So because he was unable to be controlled, and that they told that the accused was not taking care of his clothes also. So all these things. And one more point is accused and his family are from a poor strata. The appeals court held that we cannot expect a poor accused or a poor family of the accused to maintain meticulously the medical records of treatment of the accused and leading expert evidence as per law. So all these facts the appeals court took note of and held that doubt is created, and the apex court in this case took the view that order of trial court is bad in law and so also of the high court. One more point which the apex court in this case took note of: court shall put court questions to the witness for the prosecution to know whether the accused was of mental illness or not, even during trial or before trial, as the case may be. So the apex court took note of its decision in the case of State of Rajasthan versus Ani, that is 1997, Part 6, Supreme Court cases, page number 162. In that case, the apex court held that a judge should not be a mute spectator in the trial. Hear both sides as a spectator, at the end work as umpire, acquit or convict the accused. But the apex court held that a judge should be dynamic, he must be active during trial, and court shall participate effectively in the trial and elicit required materials from witnesses in appropriate cases. In this case, the apex court held that the trial court did not put questions to the witnesses to know whether the accused was mentally well or not, as on the time of the offense or before it. So the apex court made use of its decision in State of Rajasthan versus Ani. It's also very important, and it is held by the apex court that it is granted to the accused or of acquittal, giving to accused the benefit of doubt under law, and 84 of APC was invoked by the apex court, order passed by the trial court, order passed by high court were set aside. The accused was set free after a long drawn battle. Offense in 2006, the matter was disposed of in beginning of 2019. So he fought battle for nearly 15 years, but at the end of the day, he was acquitted by the apex court. So this case tells in brief what are the necessities which involve in a trial of a case wherein the accused has set up the plea of insanity, plea of what's called as unsoundness of mind. So for the prosecutor, for advocate for the accused, for the court also, what care and caution they must take appropriately is stated by the accused, by the apex court in the above case in a very succinct manner. So the case of Devidas Loka Rathod for the state of Maharashtra, in that case, the apex court stated and discussed the ratio of as many as 11 decisions of which are discussed. So my only appeal to the audience, who may be advocates, who may be prosecutors, law college students, or even sometimes judges also, that what keep in mind the things which the apex court laid down very clearly in the case of Devidas Loka Rathod. And with this, I'll not take much of your time. Given fact the matters of a given case to touch all the niceties. If Vikas says I can just go further, I will go further. But in this case, I given the pre-factual matrix, I given the legal pleas involved, and I have stated about role of judge, role of the magistrate, JMFC also in the beginning, role of IO, role of prosecutor, role of counsel for the accused, and role of one court also. So 6 or 7 facets of working of the stakeholders was discussed by the apex court. And as you all know, apex court will rarely intervene and upset 2 concurrent orders of conviction or acquittal. In this case, the apex court examined thoroughly the entire factual matrix and even documentary evidence, and later on by writing a detailed judgment stating all these facts. 12 ratios of 12 cases are made use of by the apex court in this case to state that the accused took steps to create doubt in the mind of the court that he is covered by the exception under section 84 of the IPC. So with that, the next important point which I would like to touch, I will not be, I will just now touch only the 3 points because I've given you the case of, factual case of the previous one. The next point is 2020 part 7 SCC page number 391. Muhammad Anwar versus State NCT of Delhi. In this case, the accused produced Xerox copy of OPD card, outpatient department card, and mother of the accused gave to court affidavit saying that my son was not well mentally quite long back and also as on the date of the offense. So OPD chit, OPD card of hospital was given to the court, Xerox copy. Number 2, mother of accused gave to court affidavit evidence saying that my son was having mental illusion. So in this case, the apex court held that the plea of insanity is not properly proved. Production of Xerox copy of OPD card and statement of mother of accused by way of affidavit cannot prove that accused was not well mentally as on the date and time of the incident. This is the case of Muhammad Anwar versus State and City Delhi. That is a very recent case. That is 2020 part 7 SCC page number 391. In this case, the apex court held that for the prosecution, they must prove their case beyond all reasonable doubt. For the accused, it is just preponderance of probability under section 105 of the Evidence Act. The next point is namely 2019 part 19 SCC page number 797. Santosh Maruti Mane versus State of Maharashtra. Here, the apex court held that conduct of the accused prior to the incident, immediately prior to the incident, during the incident, and awareness during commission of the incident, all these things are material. Conduct of the accused prior to, immediately prior to, during the incident, and awareness during the entire incident being committed by him, they are relevant, and onus is on the accused to prove that he was insane. In this case, the facts are very interesting. The accused was driver of a State Transport Corporation bus. He wanted, he did not want to night shift the bus. So he quarreled with the depot manager saying that don't give me tonight night shift. You shift it on the next day in the morning as day shift. And the depot manager did not accede to the request of the driver. So night duty was given. He was not given the day duty of the next day. Being upset, what he did is he took the bus in great speed inside the bus depot, and there he he ran over 2 or 3 persons who were in the bus depot. So they were killed. And he took the bus outside the main road. There he killed 6 persons. So 8 or 9 persons were killed by him by use of the bus of the state corporation, because the accused was not accommodated by the depot manager in giving day shift in place of night shift fixed to him on that night. So in this case, he was upset because the depot manager did not accommodate him. And in this case, he raised the plea of insanity, and his plea was not accepted by the trial court, High Court and also Supreme Court of India. Both courts gave finding that with intent he caused death of 8 persons, 9 persons. So the plea of insanity was not granted by the Supreme Court of India also. So here the facts are that conduct immediately after prior to the incident. During incident, see, he caused death of 2
It's 7
persons.
o'clock.
Again, he took bus to the main road, killed 8 persons who were going on the road. So in this case, the appeals court held that see conduct prior to, see conduct when he committed the offense, see conduct during the course of commission of the offense. All these things keep in mind and then go forward. Next case is Uttam Nandaram Somamshi versus State of Maharashtra. Very important case. 2016, part 30, SCC, page number 205. In this case, the defense of insanity was set up, but facts of the case indicate after assault and death of a person, the accused went home, performed puja. So he prayed to God to kindly see that I am escaped. So he performed puja, he prepared tea, he had tea. In court, his plea was, I was having this mental illness about 9 years prior to the incident, and when the offense occurred, it relapsed. The appeals court held this plea cannot be accepted because after the incident, the accused performed puja. So pray to Almighty, yes, he kindly say that I am not caught. And he prepared tea, had good tea, and he got more vigor. So in this case, the appeals court turned down request of the accused under section 84 of the IPC. And as regards legal insanity versus medical insanity, we are concerned with only legal insanity but not medical insanity. That is 2011, part 11, SSCC, page number 495, Surendra Mishra versus State of Jharkhand. In this case, after incident of death of a person, the accused ran away and threw the weapon in a well to destroy evidence. This accused took up in court the plea that he was insane. The appeals court turned down. See, he was so fine, so meticulous, he killed and ran, and while going, there was a well nearby. He threw the weapon in the well to see that the material of the offense is, destroyed. So the appeals court held that defense of insanity cannot be granted. So with this, I completed my slot of 1 hour. If Vikas wants to speak, wants to tell me to speak for some more time, I can speak. But the audience today, it is Sunday, and they have performed, they have observed what you call colorful Holi. If there were questions, I'll be glad to answer. But I've told you in a nutshell, duty of the stakeholders, duty of police, duty of the court, duty of prosecution, duty on the part of the accused to prove that the accused had mental illness. Regarding standard of proof for the prosecution and for the accused, they are different. And we are only with the aspect of, insanity being legal, but not mental incapacity, but not mental, insanity. I've discussed with you threadbare the law on the point, starting from law of England, ending with the appeals court judgment of the previous year.
Yes, sir.
Yes.
as rightly put across by you, that the niceties of this unsound mind and legal as to to go about the legal insanity and mental insanity. The subtle differences between the two have been nicely put across and rightly said by you, right from the England law, when the attack was on the Prime Minister, etc. You have taken us to the latest case law. And I'm seeing that you have explained in such a nice manner. Rather than any questions being posted, it's all thank you the way you have expressed it. But in a lighter vein, there's one joke that a person goes to a lawyer, he says that kindly help me that I have committed a murder, how I have to say. He said the only way for you is that whenever we ask in Punjabi, they say you say for, that it's like the bird has flown away. So any questions posed by him, he always said for. And when by the end of the session he was acquitted, the lawyer says, kindly give my fees. The client says for.
Yeah.
So that's the way sometimes you tutor a client for the purposes of examination, cross-examination, that how the mental insanity could have been worked upon. And thank you to all the participants who have been watching us live on the Facebook, YouTube, as well as on this platform. And as I said at the first brush when we introduced Mr. V. Angadi, that his sessions are quite insightful and on a different perspective on which normally we don't find much material on the social media as such. And his insights, as we have seen way back from 1843 of the Magneton case till 2020, he has taken us to the entire spectrum of the case law. We are all indebted for him. And do stay connected with us and keep on sharing, like, and subscribe to our YouTube channel of Beyond Law CLC, wherein we have uploaded all these webinars. And you can also like to our Facebook page as well as Instagram, so to have the latest updates. Thank you, everyone. And to all those participants who have enjoyed Holi today, best of our wishes from the team of Beyond Law. And wherein the Holi is tomorrow, for them also happy Holi in advance. Thank you, everyone. Stay safe and do take care that Corona is growing like anything. So take all the preventive measures. We can always enjoy the festival, but the precautions are to be taken at the first brush. Thank you, sir, once again.
So thank you, Mr. Vikas. Thank you all the participants. It was nice for me to, go through the case law on the point and tell you. My focus is to see that the court does duty properly, the yoke does duty properly, and so also the accused advocate, because I've given you various insights of a case. I've taken you a live case. I've given you the facts. Then I told you all the principles. Because saying just facts in simple words or saying only the principle of law in simple words is of no use unless we know the factual matrix. So I am very sure that you are benefited. If I got doubts, you are free to put to me either in the coming sessions where I may participate, or you may take from Sri Vikas my contact number. I'll be there to assist you. So thank you very much, and I thank Vikas once again for giving me the opportunity to spend 1 hour and share my knowledge. I worked extensively as a trial court judge, and have experience of varied character. And these things, they are very, very important. Sometimes we miss them. A case of acquittal, we get order of conviction. A case of conviction, we get order of acquittal. So this case has set in all the important niceties of the law on section 84 of the APC only. So thank you. Namaste. Jai Hind.
Namaste. Jai Hind. Namaste.